Let's call the case People versus Jalen Robbins.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Robinson, who is approaching. State your name, sir.
Jalen Robinson. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
My understanding is the defendant is going to be pleading guilty to the as charged to domestic violence, the 93-day offense. Upon a successful plea to that charge, at sentencing, the defendant, there is an agreement that he will be sentenced under 7694A, the preferred program. That's the court's full understanding of the agreement.
Correct, Your Honor. Correct.
Oh, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth so be got.
Yes.
Lower your hand and state your name.
Jalen Robinson.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, a $500 fine plus court cost. Do you understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty. Guilty.
Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Nope.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of July 11th, 2022, at the location of 4820 Washtenaw, apartment B11, Pittsfield Township, Washtenaw County, state of Michigan, what did you do on that date involving a Giovanna DeMarco that makes you think that you're guilty?
Just touched her when she didn't want to.
Okay. Were you guys involved in a fight of some type or an argument?
Argument.
You were involved in an argument?
Verbal argument.
And you touched her in some fashion?
Yes. And without her consent.
Pardon?
Yes, without her consent.
Man. So you said you touched her and she didn't. Where did you touch her?
More so like the waist.
All right. And you didn't have her permission to do that?
No.
Okay. And you did that intentionally?
No.
You didn't touch her intentionally.
Mm-hmm.
He's asking if you touched her intentionally, like it wasn't an accident. Like you touched her.
Like it wasn't an accident.
Like you touched her.
Like on purpose.
Yes.
So yeah.
Yes.
Okay. Yes.
Okay. I'll ask the question again. Did you intentionally touch her when you said you touched her on the waist?
Okay. Yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
Correct. And what is her relationship to you?
Right now, or nothing.
It's probably not good right now, but what was it at the time?
I'll say dating. Yeah.
I'll say dating.
Yeah, because we wasn't.
What was your relationship with her?
We wasn't boyfriend girlfriend, so I'll say dating. We were intimate. I don't know.
Okay, that works. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. And have the court complied with the court ruling, would it be proper to accept his defendant's plea?
Yes, Your Honor. Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions will be. Thank you, sir.
Where's that?
You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right. Thank you. Court does call the case of the people versus Cedric Blair.
Assistant Public Defender's trying to protect on behalf of Blair, who is opposed. Mr. Blair, state your name for the record.
Cedric Blair.
Judge, we're asking for an adjournment in this matter.
You have his violation from the second.
I do, Your Honor.
Let's address that.
Okay. Your Honor, I do understand that the violation report indicates a number of missed tests as well as a number of positive tests on the SoberLink device. And I see also that there was a missed test on 129, and the test before that on the 22nd was positive. I've had an opportunity to speak with my client about this. Mr. Blair he was very upfront with me. He wants to be very upfront with the court. He has admitted that he has been struggling. He states that he has been trying to do this on his own, but it's clearly something that he cannot. I've spoken with him about all of the options available. We're going to ask, I do have on the printer, but I can submit.
Is he admitting to the violation?
He will be admitted to the violation.
Okay, go ahead. I'm sorry.
I do have a release to treatment order drafted up if the court would be willing to sign that. I've explained to him the benefits of a lot of the treatment facilities that Washtenaw County offers, or at least we're able to get him to. And he says that he wants to take a serious attempt at this. He's looking to reunite with his 18-year-old daughter, and he wants to be the best version of himself when he does that.
If I may, I'd also like to add that I have 2 different interviews coming up. And if it's somehow that I am able to walk out of here without going to treatment, I mean, treatment is definitely an option, but could we maybe, I would suggest an alcohol tether versus the SoberLink, because I have actually forgotten this in places before, which is why I've missed a couple tests and whatnot. But that would be.
Well, the missed tests don't bother me as much as your positive test. And the SoberLink doesn't, or the Scram doesn't necessarily help with that. We got to find a way to get your addiction under control, and to really have you fulfill what your counsel's indicated is probably the most admirable thing you want to do, and that is be the best version of yourself for your daughter. All right. If that requires me to not let you walk out of here, that's what I'm going to do. Okay. Because I think you want to do that. And I just looking at the best way to do it. You had a number of, you're really slipping. And I'm not, in saying that, I'm not saying that you weren't trying. I think that you were. You just have come to the realization you can't do it yourself.
I'd also like to add, if I may, another thing that for my stress is trying to find employment. And I have, like I said, I have an interview today at 1:00, and I have an interview at Biggs tomorrow. That was part of my stress and my basis for not coming to drop. I called the number, but if I didn't have the money, I didn't come. Because, I have to.
What should have been a routine court appearance quickly took an unexpected turn. The defendant stood before the judge after allegedly violating the conditions of his release. The court reviewed his record, and it became clear that previous warnings had made little difference. The judge questioned whether the defendant was taking the court's orders seriously, pointing to repeated concerns about alcohol and compliance. The defense asked for another chance, but the judge wasn't convinced. Instead of another warning, the court delivered a firm message: every defendant is expected to follow the rules, and repeated violations have consequences. The hearing served as a reminder that judges can take immediate action when they believe court orders are being ignored.